This video will talk about how to set up a revocable living trust as part of your estate plan. I recommend doing a trust plan rather than a will plan. A will does not avoid probate court. It is public, meaning anyone can go down to the court and request a copy of your will filed with the court and see who your heirs are, what you have left for them, and when it was given to them. With a will, your family still needs a court judgment to access your bank accounts, real estate, and other property that you have left in your will. The process can be long and expensive. A will is just a letter to the judge that tells the judge how you want your assets divided up in some way that is different than the intestate laws of the state. Intestate just means you died without a will. One valuable thing about a will is that you can appoint guardians of your minor children if something happens to you. A trust, on the other hand, will avoid probate court entirely. It is completely private. Your appointed trustee can get immediate access to your financial accounts and other property, and you can determine in the long run how you want your assets distributed. So what is a trust? A trust is not an entity like an LLC or corporation. A trust is just an agreement where one person called a trustee holds and manages assets for the benefit of another person called a beneficiary. There are three parties to a trust: the trustor, who is the creator of the trust, the trustee, who is the manager of the trust, and the beneficiary, who will receive a benefit from the trust. When you first set up a revocable living trust, you are all three: the trustor or creator, the trustee, manager, and the beneficiary. Here's an example of a trust agreement. Imagine you have a savings account with $10,000 and you want to make sure the money is used to pay for your child's education if something happens to you. You create a trust, naming a trusted friend as the trustee. The trustee will hold and manage the $10,000 and ensure it is used only for your child's education as you specified in the trust agreement. A revocable living trust means that you can change, amend, or even revoke your trust at any time during your lifetime. A revocable living trust will not affect your taxes during your lifetime. It's important that you can revoke or amend your trust because there are three things that you will never know. Number one, when you will die. Number two, what you'll own when you die. And three, what the estate tax exemption will be when you die. You can name your trust whatever you want. Typically, people will name their trust after their names. For example, a married couple, John Doe and Jane Doe, would name their trust the John and Jane Doe Revocable Living Trust. The title of your trust will include the date that it is established. For example, if you signed your trust documents on March 22nd, 2025, the trust name would be the John and Jane Doe Revocable Living Trust, under authority, dated March 22nd, 2025. A trust can seem complicated, but it is much simpler to understand if we draw a picture. We will have this box represent a trust. You can put items in the box or trust, and you can take them out of the box or trust. You can put your house, your bank accounts, your cars, your personal belongings, your business into the trust, and take them back out again. You can also name the trust as the beneficiary of your life insurance policies and your retirement plans. An estate plan is a plan of what happens over time. For single individuals, you will have your revocable living trust followed by your passing. The revocable living trust then becomes irrevocable and asset protected until distributed to your heirs. Married couples, on the other hand, must plan for what happens at the death of the first spouse and the death of the second spouse. At the death of the first spouse, you could make some specific distributions. For example, let's say the husband had some collection of guns he wanted to give to his sons at his death, and the wife had no interest in keeping them. Or maybe the wife has some assets she wants to pass to her daughters. Those can happen at the first death. After the first death regarding the trust, you have a few options. Your first option is to keep everything the same. You can have a basic revocable living trust where the surviving spouse has 100% control of the trust. There is no asset protection and no tax planning. The trust is still completely revocable. The surviving spouse can amend the trust, change the beneficiaries, and even revoke the trust and create a new trust. The second option is that you can have this trust split in half into two trusts, the survivor's trust and the decedent trust. Decedent simply means a person who has died. The survivor trust is just like the initial revocable living trust that can be amended and changed or revoked at any time by the surviving spouse. It provides no asset protection and no tax planning. The decedent's trust, on the other hand, becomes irrevocable. An irrevocable trust can only be changed or amended by going to court. The assets in an irrevocable trust are protected from creditors. The surviving spouse can be the trustee of the decedent's trust and can still use the funds or assets in the decedent's trust for health, education, maintenance, and support for the surviving spouse and beneficiaries provided for in the trust. When filling out your forms to create your estate plan, you need to decide if you want the surviving spouse to have full control of the trust and have no asset protection, or if you want the trust to split in half and have asset protection. Even if you don't split the trust in half, we will create a disclaimer trust where the surviving spouse has 8 months after the first death to still split the trust and disclaim assets into the decedent's trust. At the second death, all of the assets are combined into an irrevocable trust. When the trust was first established, typically both spouses were co-trustees of the trust, unless otherwise specified. One spouse dies, the surviving spouse is the trustee of the When one spouse dies, the surviving spouse is the trustee of the survivor's trust and can also be the trustee of the decedent's trust, although someone else can be appointed trustee of the decedent's trust as well. When the second spouse passes away, someone else designated by you will become the trustee or manager of the trust. We recommend appointing a trustee, a follow-up trustee, in case the first trustee cannot serve as trustee, and a third backup trustee. You must also decide how you want the trust assets to be distributed among your heirs or beneficiaries. One of the most common ways that people distribute assets among heirs is called per stirpes, which means that an equal share is given to each branch of the family. If there are 3 children, each child receives 1/3. If one of the children has passed away, and that person had 2 children, those 2 children would each receive 1/6. This can be changed. You can give different items or different amounts to different heirs. You can specifically disown a family member if you wish. You can also leave assets or funds to grandchildren. You must also decide when you want assets distributed to heirs. You can do an outright distribution to your heirs, where as soon as you die, assets can be immediately distributed to all of your heirs, regardless of age or situation in life. You can also distribute the assets based on ages. Maybe you don't want anyone to receive their inheritance until they reach the age of 25, 30, or 35. Maybe you give them 1/3 at 25, 1/3 at 30, and 1/3 at 35, or any ages or amounts you want to pick. You could also never give the assets to your heirs and create what's called a dynasty trust. With a dynasty trust, your heirs don't inherit the money, they become trustees of the trust, and it remains that way throughout their lives. The assets are always protected, and they can still use the assets for health, education, maintenance, support, investing in businesses, or borrowing against it. There's a number of things you can do to retain wealth in the family with a dynasty trust. Your trust will also include spendthrift clauses. A spendthrift clause means that a beneficiary is restricted from accessing or controlling trust assets, preventing them from being squandered or seized by creditors, and ensuring the assets are managed by a trustee. For example, if a beneficiary has a drug addiction, the trustee can manage the funds for the benefit of the beneficiary, but not give the funds or assets over because they could be squandered on drugs. Or if a beneficiary is being pursued by creditors, The trustee can hold the assets in the trust so that they cannot be reached by creditors. There could be a situation where there's nobody to inherit from your trust, and so you'll want to create a remainder and residue of your trust. You want to mention what would happen with the remainder and residue of the estate in case, in some instances, your heirs pass away before you, or you have no beneficiaries to inherit or take control of your assets. Some things to consider when picking beneficiaries and how to distribute assets to heirs are how inheritances are typically lost. 1. Future divorce. 42% of people divorce during their lifetime. Inherited assets can become commingled with marital assets and divided in divorce. Mismanagement. 40% of individuals inheriting less than $100,000 will spend or lose the entire inheritance, and 18.7% inheriting more than $100,000 will spend or lose the entire inheritance. Extreme debt or bankruptcy. The number one reason people declare bankruptcy in the United States is from a medical emergency. Maybe an heir could also be involved in a lawsuit and lose their inheritance through court judgment. Lost work ethic. Children who receive an inheritance were worth 4/5 less than others in their same profession who did not. Unprepared children who inherit money are susceptible to excessive spending, identity loss, and guilt over receiving money they did not earn. You may want to modify your estate plan. Some situations where you may want to modify or change your estate plan can include divorce, change in property, death of loved ones, physical or mental incapacity of self or loved ones. You want to add or remove an heir or beneficiary. Maybe you want to transfer property for asset protection.